The timeline evolution of reservations in India. So what is Article 14? Please revise once. What is Article 14? What is Article 14? It talks about rule of law and also equality before law and equal protection of laws. To know about the evolution of the reservations in India, first let us know two more articles of the Indian Constitution, Article 340 and Article 46. We have already discussed Article 14, 15, 16. Now let us know these two articles. Firstly, what is Article 340? According to Article 340 of the Indian Constitution, right? The President of India has the authority to form a backward class commission to look after the status of BCs in India, right? To look after the status of BCs in India, the Article 340 empowers the President of India to form a backward class commission. And what is Article 46? Article 46 is a directive principle of state policy. It is nothing but a directive principle of state policy, right? It is not a fundamental right, it is a directive principle of state policy. DPSPs can be made applicable only by a law. DPSPs are applicable only by a law or policy. So according to Article 46, it is a duty of the state to protect economic and educational interest, economic and educational interest of SCs, STs and backward classes in India, right? So according to Article 46, the state shall protect the educational and economic interest of SCs, STs and backward classes in India. Now let us see the timeline, what exactly happened. So firstly 1950. So what happened in 1950? In 1950 we have Constitution of India came into force, and articles which are linked to the reservations is Article 14, 15, 16. These are the direct articles linked. And indirectly Article 340 and also Article 46, which are linked to the our reservations topic. Then in 1950 what happened was very, very important. Tamil Nadu government, Madras government it is called then, Madras government has issued a notification. In 1950, there is no SC and ST reservations. When by which Amendment Act SC ST reservations came? Article 15 clause 4, First Amendment Act. So the Madras government has issued a notification. What is that notification? Right, to provide admissions into educational institutions. But Madras government has issued a notification in 1950 by giving reservations to SCs and STs. In 1950, Constitution did not allow SC ST reservations. There was no SC ST reservations. But Madras government has issued a notification here, directly issued a notification. So this is against the fundamental right of Article 15, right? So the reason Champakadurai versus State of Madras, 1951. Now what happened? This Champakadurai Rajan went to Supreme Court saying that Madras government notification is against the fundamental right. Why it is against the fundamental right? Because it is providing reservations to SCs and STs, which is not part of the original Constitution. Then Supreme Court sent a notice. To Madras government asking for explanation. Now when the notice was sent to Madras government has replied saying that yes, we have given reservations to SCs and STs as per Article 46, not as per Article 15. Now what is Article 46 saying? It is a duty of the state to provide the economic and education interest of SCs, STs and PCs. So keeping this Article 46 in view, I wanted to give reservations, not following the fundamental rights. Now there is a debate. Fundamental rights versus DPSP. Can you compromise fundamental rights for implementing DPSP is a question mark in front of Champaka Rajan case. You have compromised the fundamental right now. To implement directive principle of state policy, you started compromising the fundamental right, because fundamental right never mentioned about SC/ST reservations only. Now what Supreme Court said? Supreme Court said fundamental rights are superior than directive principles of state policy. Any law which takes away the fundamental rights cannot be allowed. So this notification was declared as unconstitutional. This notification was declared as unconstitutional. And so the reason 1951 Government of India has brought the first Constitutional Amendment Act. The first Constitutional Amendment Act was brought to include the provision called Article 15 Clause 4, which provides reservations to SCs, STs in educational institutions, in all the educational institutions, excluding minority educational institutions. So the first Constitutional Amendment Act emerged in India, and Article 15 Clause 4 emerged in India. So this is one chapter, this is one point. Now what is the next one we have? In 1953, following Article 340 of the Constitution, the President of India has formed the first backward class commission, the first BC commission, which is called Kaka Kalekar Commission. Kaka Kalekar Commission. The first backward class commission was formed in 1953 following Article 340 of the Constitution, and this is called Kaka Kalekar Commission, to look into the status of backward classes in India. Now what did Kaka Kalekar Commission said? Apart from SC and STs, leaving SC and ST, apart from SC and ST in India, there are 2,740 backward classes who need reservations. In the country. This is the recommendation given. 2740 sections of the people are really backward, and please provide them reservations, is what it said. Please provide them reservations. That is the thing our Kaka Kalekar Commission said. But Nehru government said, no, we were just in 1953, Constitution came into force in 1950. We are a least developed country. We are not in a position to afford this kind of reforms. We were not in a state. But Nehru government has asked all the states, to notify a BC list every year, annually. So the government of India has asked the states to notify a BC list annually. This we will come back again. This point is very important when we discuss this 105th Constitutional Amendment Act. 105th Amendment Act is linked to this. So Kaka Kalekar Commission has said something, but Nehru government did not accept it and said the states in India shall notify BC list. So by the end of 1953, reservations were only given to SCs and STs. SCs were given 15% reservations and STs were given 5.5% reservations. Totally 22.5% reservations are given. Everything was going smoothly. Now, 1963. 1963, Balaji versus State of Mysore. Balaji versus State of Mysore, that is Karnataka. Balaji versus State of Mysore case. Supreme Court said, let us have a cap on reservations. So what is that cap? Let us ensure that the reservations will not cross 50%. Make sure that reservations will not cross 50%. Right? In which case Supreme Court said reservation should not cross 50%. For the first time, Balaji versus State of Mysore case, very, very important for the exam. This is your 1963. 1979. In 1979, VP Singh government has formed the second backward class commission. The second backward class commission. VP Singh government has formed the second backward class commission headed by BP Mandal. This is famously called BP Mandal Commission. BP Mandal Commission. We will see in this in news all the time. Almost weekly, at least once, you will see this name called BP Mandal. Sir, what did BP Mandal say? Very interesting. BP Mandal Commission said, point number 1. Apart from SCs and STs, there are 3,743 sections who are really backward in India. 3,743 sections are backward in India. And these sections in India, 3,743 sections in India constitute 52% of the Indian population. 52% of the Indian population. And this 52% should be immediately given 27% reservations. This 52% should be immediately given 27% reservations. Why 27, sir? Because Balaji versus State of Mysore, 15, 7.5, 27. That is 49.5. It should not cross 50%. So, it has recommended 27% reservations to 52% backward classes apart from SCs and STs in India. This is the problem. This is a serious issue. 1979. Next, Indira Gandhi came up with Garibi Hatao. So, 1979, after this, Indira Gandhi came into power. She did not care Mandal Commission report. Rajiv Gandhi came into power. He was not concerned about Mandal Commission report. And at last, the VP Singh government in 1989, there was a Office of Memorandum issued to provide 27% reservations to OBCs in India. When this was announced, there were revolts in the country. OCs, specifically OCs, started revolt saying that I also want reservations. Everyone started asking reservations. This was dropped. This was challenged in the court. It was dropped. In 1991, PV Narasimha Rao government came into force. In 1991, PV Narasimha Rao government came into force. Where PV Narasimha Rao government in 1991 said, do one thing. Issued an office of memorandum, which consists of two things. This was not VP Singh government. This was Janata government, Moraji Desai government. Which one? This one. Second BC Commission, Moraji Desai government. I mentioned VP Singh, I remember. That is wrong. This is Moraji Desai government. Charan Singh Moraji Desai, 1979. Then we had VP Singh government in 1989. Then we have Narasimha Rao government. He has issued a Office of Memorandum, which consists of two things. Point number 1, provide 27% reservations to OBCs. Provide 27% reservations to OBCs. 2, provide 10% reservations to economically weaker sections. So in which year? 1991 only, economically weaker section reservations were proposed by our PV Narasimha Rao government Office of Memorandum. Now, this is challenged in the court. This was challenged in the court. And the famous case was Indira Sawani versus Union of India case, 1992. Supreme Court gave a clarity over reservations in Indira Sawani versus Union of India case. It gave very much clarity on different issues. What is that clarity? Let us see one by one. Point number 1. In Supreme Court, Indira Sawani case of Supreme Court, Supreme Court said, point number 1. P.V. Narasimha Rao's government office of memorandum providing OBC reservations of 27%, OBC reservations of 27% is valid. But to provide reservations to OBCs, 3 conditions must be satisfied. It said it is valid, no problem. Give reservation. You want to give reservations? Give. But make sure that 3 conditions are satisfied. Condition number 1. Make sure the reservations will not cross 50%. Make sure the reservations will not cross 50%. Condition number 2. Provide reservations to only socially, economically backward classes in the OBC. Within the OBC, don't provide the reservations to everyone. Provide to poor of the poor in OBC. That is socially, educationally backward classes. Provide on the basis of socially, educationally backward. This is mentioned directly in the Constitution only, Article 16, Clause 4. 3, very, very important again. It said, make sure that the sections of the society whom you are giving reservations are not adequately represented in the government jobs. Ensure, for example, you want to give reservations to a particular caste. Make sure these people in the caste are not there in the government jobs already. If they are there, why? What is the need for giving reservations? Provide to the people who are only not there, who are not adequately represented. And very, very important, do not compromise on Article 335 of the Constitution. Do not compromise on Article 335 of the Constitution. Sir, what is Article 335? What is Article 335? Article 335 says, claims of SCs and STs without compromising the skills and efficiency. Without compromising the skills and efficiency. You provide reservations to anyone. Any Tam, Dick and Harry, you provide reservations. But do not compromise on the skills. On the name of providing a job to a person, you don't compromise on the skills and efficiency. Are you getting my point? You need a civil engineer. Because you want to provide reservations, don't hire a doctor. He can't do civil engineering work. Are you getting my point? Do not compromise on Article 335. So, specially there are 3 conditions. Condition number 1, 2 and 3. Supreme Court in Indira Sawani case said, OBC reservations can be given, but ensure that the 3 conditions are satisfied. Point number 2. Supreme Court in Indira Sawani case rejected 10% reservations to economically weaker sections. It rejected 10% reservations to economically weaker sections. Why? Because of 2 reasons. Reason number 1. When you are giving reservations to economically weaker sections, it is crossing 50%. It is more than 50%, taking to 60%. So you cannot give. Point number 2, very, very important. Reservations as per the constitutions is given only on the basis of socially, educationally backward class, not on the basis of economic class. You can give, economy can be a criteria, but it cannot be a basis. You give reservations to social and educationally backward class only. సామాజికంగా మరియు ఈ ఆర్థికంగా కాకుండా ఎడ్యుకేషనల్ విద్యాపరంగా బ్యాక్వర్డ్గా ఉన్న వాళ్ళకి మాత్రమే రిజర్వేషన్స్ ఇవ్వాలి. ఈ సోషల్ ఎడ్యుకేషనల్లీ బ్యాక్వర్డ్ క్లాసెస్ ఎలా నిర్ణయిస్తారు సార్ అంటే డబ్బులు యాన్యువల్ ఇన్కమ్ ద్వారా నిర్ణయిస్తారు. అదొక క్రైటీరియా పెడతారు, కానీ అదే క్రైటీరియా కాదు, అది బేసిస్ కాదు. దట్ కెన్ బి టేకెన్ యాజ్ ఎ క్రైటీరియా టు ఫిల్టర్ ద పీపుల్. సో దిస్ ఇస్ యువర్ సెకండ్ పాయింట్, very, very important. Now point number 3, again important. Supreme Court in Indira Sawani case said, under special circumstances, but special circumstances లో 50% రిజర్వేషన్ క్రాస్ అయినా పర్లేదు అని చెప్పింది. Even if the 50% reservation crosses, it's fine, but special circumstances ఉండాలి. For example, our Tamil Nadu, which gives reservations up to 68%, that was termed as a special circumstances. Presently, EWS reservations, special circumstances. This is a third point. Point number 4. Supreme Court said, "Arey, you should give reservations to OBCs, na?" Correct? But Supreme Court said only to the socially, educationally backward classes of OBCs. Yes or no? Then how to decide? So to decide to whom the reservations will be given in OBCs, Government of India shall constitute a committee to decide the criteria. Government of India shall constitute a committee to decide which OBCs will receive the reservation. So, Government of India in 1993 constituted Ram Nandan Committee on deciding the OBC criteria. And this Ram Nandan Committee came with something called creamy and non-creamy layer. Now, what is this creamy and non-creamy layer? Based on annual income. Annual income. When Ram Nandan Committee gave the definition, it said 2 lakhs annual income, then increased to 6 lakhs. Presently it is 8 lakhs. So creamy layer, non-creamy layer. So creamy layer, non-creamy layer lo evarku vastayi reservations? If annual income is less than 8 lakhs, వాళ్ళు creamy layer lo vastara, non-creamy layer lo vastara? Less than 8 lakhs unte వాళ్ళు ekkada vastaru? Non-creamy layer lo vastara. Less than 8 lakhs. Less than 8 lakhs. So they are given reservations. More than 8 lakhs, they are creamy layer. Plus 8 lakhs, they are creamy layer. Are you getting my point? This is what happens. So this is Ram Nandan Committee, OBC reservations, criteria kosam. Criteria, Malli I am talking not basis, criteria. Point number, next point. What is the next point? We have 5. Okay, you wanted to give reservations. OBCs are given reservations, but there should be some commission to know the status of the welfare of the reservations. You wanted to give reservations, na? You wanted to give reservations for their empowerment. Now, till when you will be empowered? Till how you know that they are empowered? There should be a body. So Indira Sawani case said that constitute a commission to review the status of OBCs time to time. And so Parliament by a law has formed National Commission for Backward Class in 1993. In 1993, Government of India has formed National Commission for Backward Class, and this is very important. This is in news. This was asked in your mains this year, mains paper. What is National Commission for Backward Class, and how did it evolve, and what are its functions? Now, this National Commission for Backward Class was given constitutional status by 102nd Constitutional Amendment Act 2018. By 102nd Constitutional Amendment Act of 2018, it was given constitutional status by adding Article 338B of the Constitution. It was formed as a statutory body. It was formed as a statutory body. And it was taken, it was given the status of constitutional status. చట్టం ద్వారా వచ్చేది, చట్టం ద్వారా ఏర్పాటు చేసేది స్టాచ్యుటరీ బాడీ అంటారు. రాజ్యాంగం ద్వారా ఏర్పాటు చేస్తే కాన్స్టిట్యూషనల్ బాడీ అంటారు. In Indira's Sawani case, Supreme Court said one more point. It said reservations shall be given at only entry point, only entry level. Reservation shall be given at only entry level and not in promotions. Not in ప్రమోషన్స్లో రిజర్వేషన్ ఇవ్వకూడదు, ఓన్లీ ఎంట్రీ లెవెల్లో మాత్రమే ఇవ్వాలి. పాయింట్ నెంబర్ 7. Supreme Court in Indira Sawani case said no continuity of, or you can continue the backlog post. Ensure that the backlog post will not cross 50%. Suppose 2021లో ఎస్సీలకు ఒక 15 పోస్టులు ఇచ్చారు, కానీ 15లో 10 ఫిల్ అయ్యాయి, 5 మిగిలిపోయాయి. ఈ 5 2022లో 2022 యూ వాంట్ టు టేక్ ఇట్, యూ యాడ్ దిస్ 5 పోస్ట్, బట్ ఈ 5 పోస్టులు యాడ్ చేశాక ఇట్ షుడ్ నాట్ క్రాస్ 50%. 50%లోనే ఇది కూడా ఉండాలి. You cannot cross, you cannot ensure that the backlog post can be continued, but it will not cross 50%. Understood? Okay. So these are the points set by Supreme Court in Indira Sawani case. So this is what said by Supreme Court in Indira Sawani case. But ఊరికే ఉంటారా అండి మన వాళ్ళు? ఊరికే ఉండరుగా. 77th Constitutional Amendment Act 1995 added Article 16 Clause 4A, said made or gave reservations, applied reservations in promotions also. Not only in entry level, even promotions lo reservations ichcheddamani తీసుకొచ్చారు. Promotions also will give the reservations. Not only that, Government of India has said that you continue the backlog post, you take it to the next year, even if it crosses 50%. సో బ్యాక్లాగ్ పోస్ట్ నెక్స్ట్ ఇయర్ కంటిన్యూ చేయండి, 50% క్రాస్ అయినా పర్లేదు అని చెప్పింది. సార్ రిజర్వేషన్స్ ప్రమోషన్స్లో ఎలా ఇస్తారో అంటే సీనియారిటీ బేసిస్ మీద ఇస్తారు. ఇట్ ఈస్ గివెన్ ఆన్ ద బేసిస్ ఆఫ్ సీనియారిటీ. నెక్స్ట్ పాయింట్, blunder, Government of India compromised on Article 335. It said skills efficiency నాకు అవసరం లేదు, నాకు రిజర్వేషన్సే కావాలి. What is Article 335? We just saw skills and efficiency. So all these 4 points are against Indira Sawani case. Indira Sawani కేసులో చెప్పినవన్నిటికీ కూడా అగేన్స్ట్గానే ఉన్నాయి కదా. Yes or no? So this was challenged in Nagaraju versus Union of India case 2006. Nagaraju versus Union of India case, this was challenge. Supreme Court said, no, etlane chesko, but do not compromise on 3 things. You give anything, your wish, I don't care, but don't compromise on 3 things. Point number 1, it cannot exceed 50%. Point number 2, make sure that socially educationally backward classes ke reservations ivali. Point number 3, do not compromise on Article 335. Point number 4, make sure that they are not adequately represented. ఎలా అయినా ఇచ్చేసుకో, ఇంకా ఎవరికైతే రిజర్వేషన్ ఇద్దాం అనుకుంటున్నావో ensure that they are not adequately represented. So by 2006, this is a scenario. Now what happened after 2006? We will see. Right. By 77th Constitutional Amendment Act 1995, Article 16, Clause 4, Subclause A was added. Now keep the heading as 2019. 103rd Constitutional Amendment Act. Yeah. Government of India, under the recommendations of SR Sino, SR Sino Committee, SR Sinho Committee, has amended the Constitution and inserted Article 15 Clause 6 and 16 Clause 6. Article 15 Clause 6 and 16 Clause 6, which provides which provides reservations of up to 10%, reservations of up to 10% to economically weaker sections. To economically weaker sections. The government of India has given the following criterias. Just continue this to economically weaker sections, and can you write something else here? To economically weaker sections, to economically weaker sections of forward class communities, of forward class communities. The government of India has given 5 criterias. Criteria number 1. Annual income should be below 8 lakhs. Yeah, should be 8 lakhs. Annual income below 8 lakhs. Agricultural land of less than 5 acres. Agricultural land of less than 5 acres. Agricultural land of less than 5 acres. 3. If he is staying in a rural area, he should be having a land or plot of less than 200 square yards. He should be having a land or plot of less than 200 square yards. If it is an urban area, less than 100 square yards. And the house he states cannot be more than 1000 SFT. Cannot be more than 1000 SFT. So these are the 5 criteria. Now Telangana government is has relaxed all these 5 criteria. It is only going with the first criteria. Every government can relax it, but these are the 5 criteria. Now economically weaker section is given on economy, annual income basis, and money economy. But Constitution doesn't allow, right? Constitution said the reservations can be given only on the basis of social and educational backwardness. So this was challenged. You can keep the heading as economically weaker section reservation case 2022. First point. The Supreme Court in this case upheld the validity 103rd Constitutional Amendment Act. 103rd Constitutional Amendment Act in a 5 judges bench. Full stop, continue. While giving the judgment, Supreme Court said reservations on economic criteria do not violate the basic structure doctrine. In fact, it is a affirmative action by the state to ensure egalitarian society, equitable egalitarian society. Very, very important. This is in news now. This is in news last 2 weeks back. So that's why he might ask you, right? In that only last point, this is a controversial point and this will be challenged again. What I think, Supreme Court said the 50% cap on the reservations, the 50% cap on the reservations is applicable only for SCs, STs and BCs. OCs. The 50% cap for the reservations is applicable for SCs, STs and BCs. Okay. So 50% దాటినా పర్లేదు అని అందుకే చెప్పింది అనమాట. Right? And SC, ST, OBC cannot apply for EWS. They cannot apply for EWS. గుర్తుపెట్టుకోండి. right? So next is 2019 Maratha judgment. Supreme Court has rejected 16% reservations to Marathas. Supreme Court rejected 16% reservations to Marathas, which is given by the government of Maharashtra on the recommendations of Gaikwada Commission or Committee. On the recommendations of Gaikwada Committee. Supreme Court gave two reasons for rejection. Supreme Court gave two reasons for rejection. Supreme Court gave two reasons for rejection. One, it said there is a cap on the reservations to 50% only. There is a cap on the reservations to 50%. Two, it violates Article 16, Clause 4, which is not adequately represented principle. Not adequately represented principle. It violates Article 16, Clause 4. That is not adequately represented principle. See, Marathas are already adequately represented. Out of 280 MLAs, 120 to 130 MLAs are Marathas only. They are already there in different jobs. So, the reason the Maratha judgment was rejected. Now, in Maratha judgment, Supreme Court also said some more point, one more point. What did Supreme Court say? The states do not have the authority to maintain or notify a BC list. It is only the union which can notify a BC list. The state do not have the authority to notify a BC list. Nehru said 1953 Kaka Kalekar Commission. After that, Nehru has asked all the states to maintain BC list. You remember? 1953. So, to counter this only, continue last point, 105th Constitutional Amendment Act was made. According to 105th Constitutional Amendment Act, the states were given the authority to notify a BC list. 342A. The states were given authority to notify a BC list. That's it. 2A. Correct. What is 342? 340 is BC Commission. The President can constitute BC Commission for the welfare of BCs, not notifying BC list. To know the status of the BCs in India, the President time to time can form commission. That is what we wrote. What is 342? Is this done, everyone? Right? So by 105th Constitutional Amendment Act, the states were given authority to come up with a BC list. Now, what is 342? 341, 342. What is Article 341? According to Article 341, the President of India has the authority to notify the Union SC list. The President of India also has the authority to notify a state SC list. Who are SCs of the state? According to Article 342, the President of India has the authority to notify the Union ST list. The President of India has the authority to notify state ST list. Look at the screen. How they notify it? Government of India will form a committee and ask to give the list of SCs in India. After the report is submitted to the government, they finalize the report and give it to President. And President will notify. Similarly, the state government will form a committee to see who are SCs in the state. After the committee report is given, the state government will give that report to governor. Governor, after accepting, he will send it to President of India and President will notify it. President will notify it. You're getting my point? An SC or ST list of a union or the state is notified by the President. That is, there is no doubt. Kani, to modify that list, Parliament has the authority to modify. Parliament by a law has the authority to modify the union SC/ST list or any state SC/ST list. Imagine now Telangana government want to include one section into STs. Now Telangana government cannot do it. Telangana government can only send a recommendation. It is a parliament who has the authority to modify the ST list of Telangana, remove some sections or include some sections. Notification by the President, modification by the Parliament. Remember this. The same thing is applied for ST also, for also OBC, Article 342A. That's it. Simple as such. This is the evolution of the reservations in India. Now there is something called horizontal reservations. Now what is the meaning of horizontal reservations? Horizontal reservations are given to NCC, physically handicapped, women, right? These people. Sports quota. This is horizontal reservations within the vertical. Imagine SC, ST, BC, OBC, everyone has some reservation of seats. Within the reservation of that seats, again, there are few which are given to these people. There are few which are given to these people. Understood?